This is the Know Your Law series by Barefoot Law, a non-profit organization which uses digital innovation and technology to provide free legal information and guidance for all. For more information, visit www.barefootlaw.org.
Hello, my name is Daphne. You're welcome to another edition of Know Your Law series. Today we'll be discussing succession frequently asked questions, and we'll start off with some common terms that pertain to succession. I'm here with Kennedy, who will elaborate and discuss more on those terms. To start off, we want to know what an heir is, what a will is, what an executor is, and what are letters of administration.
Thank you, Daphne. This topic of succession, first of all, requires us to understand exactly what it entails and what it's meant to assist people with. Succession is a process where a person, having died or become a deceased person, creates an opportunity for people to take on responsibilities regarding his property and his estate, as well as have an opportunity for his family members and those who he left behind, he or she left behind, take on inheritance of parts of his property and estate. A person may die having left a will behind, which we call having died tested, or a person can die without having left a will behind, which we call intestate succession. But specifically about a person having died leaving a will, we want to talk about what a will is and what it entails. A will is a document that specifies the wishes of a deceased person, how they may want their property distributed, to who, and also appointing individuals who take over responsibility of managing the affairs of their estate. A person can also appoint someone known as an heir under a will, and this person takes on the responsibility of being a leader or the responsibility of being a caretaker for respect of the property and the management of the estate of this deceased person. Under a will, the deceased person can also appoint someone known as an executor. The executor is supposed to ensure that all the wishes specified in this will are complied with and are carried out as per what he wanted to be done. The will can also specify the nature of properties and how they're going to be managed, as I earlier on mentioned. But where a person dies having left no will, which is intestate succession, then the family has to sit together, appoint a few individuals to go before a court of law to get what we call a grant of letters of administration. A grant of letters of administration is a legal document that empowers an identified group of individuals or people to take on the responsibility of managing an estate of a deceased person, take on the responsibility of distributing property, as well as the responsibility of representing the deceased person if there are any legal processes or legal inquiries expected of a deceased person and a deceased person's estate.
All right, so we're just going to jump into a couple of questions. Inheritance pertaining to different dynamics in relationships, different situations of relationships with your friends, with your siblings, with your, children and all that. So the first one is, what can I consider as my inheritance?
All right, thank you. That's a good question. Inheritance, first of all, comes from property having been left behind by a deceased person. Property can include cars, can include land, it can include items in the homestead where the person has been staying. It can include animals in case the person has been a farmer, like in most places in Uganda. It can also include items such as a person's intellectual property rights, such as a name, if he has a reputation relating to a business, a brand. It can also relate to any titles to properties outside Uganda. And coming back to the question, if you are a person who is left behind by any deceased individual, let's say you're a spouse, you are a child, you are a dependent relative, or you are a friend, your inheritance will be any property, first of all, specified under a will. If the deceased specified that you are supposed to get a specific portion of the identified item as properties. In the event the deceased person did not leave a will, the properties left behind, which comprise what we call an estate, can be distributed amongst the family members, such as a spouse, the children, any dependent relatives, and a friend, if is available as a caretaker. Now, your inheritance will be that portion at the end of the day that you are given under will or that you're distributed to acquire, having been a part of a family that a deceased person left behind.
All right. The second question coming in is, who can inherit from me? Can it be humans? Can it be my animals, my pets at home? Or can it be corporations? If I have, let's say, a barefoot law organization, can I say I want to give out my belongings or my properties to, yes, a corporation?
In Uganda, the law provides that human beings have a legal entitlement to inherit from a deceased person. Okay. In the same way, bodies corporate can also inherit and can be given an opportunity to take up inheritance. Bodies corporate also include specified trusts, such as religious bodies who usually own properties and a board of trust. So from the identified category or named people, you have human beings, you have bodies corporate such as companies, and you also have a board of trustees in respect to churches and religious bodies. These are the specified kind of individuals or group of people and specified bodies corporate that can inherit from a deceased person.
Thank you for that. The next question coming in is, many times people live and take care of children belonging to their friends. Is such a child entitled to a portion of the estate of the deceased?
As you know, in our society, Uganda, this is something that can definitely be of can occur in the event of a person dying. The answer is yes. Any child being taken care of by a deceased person can actually get a share or an inheritance from the estate of a deceased person. In legal terms, this child is regarded as a dependent of a deceased person. They may not be biologically related to the deceased, but they are regarded as dependent of a deceased person from the way and the conduct or the relation with the deceased before he or she passes on. If they derive basics or sustenance from a deceased person, they're interpreted to be dependent on the deceased providing those things during that time of life. In the event of passing on, they are also still given an opportunity, or they still qualify to inherit from the estate of a deceased person, including getting sustenance and care from the estate of a deceased person.
Can I inherit from my boyfriend if he dies and we have a child together? Yes.
Well, you cannot inherit, unfortunately, from your boyfriend.
Okay.
By principle of the law, unless your boyfriend died having left a will. The reason is the nature of boyfriend-girlfriend relationship in our society and our legal regime is not recognized. However, the legal regime and framework of the law recognizes marriage. So when you're still in that kind of relationship, you're not considered to be married. So you may not have legal entitlement to inherit from your boyfriend. However, if your boyfriend passes on having specified his wishes as to what must happen regarding his property, his estate, and specifies you as a girlfriend to take a portion of that property or estate, then you will definitely inherit, having gotten that entitlement from the will your boyfriend left behind. Yeah.
Do you lose the inheritance from your partner if you remarry?
You do not lose an inheritance from your partner if you remarry, being that the legal obligation and the legal requirements for you under that marriage happen to have extinguished at the point of your partner in marriage having died. Okay. Now, if your partner died and you are entitled to property that you actually were able to obtain at the point of distribution, whether by enforcement of a will your partner or spouse left behind, or consequent processes that enabled you to get a share of a distribution of this property, and you indeed possessed this property and you utilize this property, then consequently remarry, you don't lose what you had in the first place obtained by virtue of inheritance. This is because, first of all, inheritance is one of the ways people come to own property. And once you own property, you have the freedom to utilize, but as well as hold it for the long term of your life. In the process of using and possessing this property, if you choose to remarry, which is a right available to you, having lost a spouse, you do not lose the legal protection, the legal empowerment of ownership over that property.
Do extramarital relationships also dissolve someone of having inheritance rights? For instance, if I am with my husband, I've had an extramarital affair, and then I come back and I still want a part of his inheritance. Does that dissolve me of that? And then also, how about the children I get from that extramarital affair? What are those dynamics like?
The answer is no.
Okay.
You do not necessarily lose entitlement to inheritance and a spousal arrangement unless this extramarital relationship is brought as a ground for divorce, dissolution of a marriage, or separation. Okay. If the partner in this relationship, for example, your husband, let's say, is aggrieved by the extramarital relationship, they have an opportunity to raise a ground for divorce before a court of law. And if the court of law justifies the ground brought before it and dissolves the marriage by way of divorce, the divorce order dissolves the marriage and thus dissolves your entitlement to inheritance under the marriage. But in the event that this extramarital relationship is not challenged or brought before a court of law to seek consequent orders of dissolving the marriage, then you may not lose your entitlement to inheritance under marriage with your partner or your husband.
All right, we'll be back with more questions on inheritance and relationships, so stick around and make sure to like, subscribe, and follow.